could the federal government really force you to buy something? I mean, even something like health insurance.
That was the absolute core constitutional question. It was right at the heart of the Affordable Care Act's individual mandate.
Welcome to the deep dive. We try to cut through the noise on really complex issues, get right to the essential core. Today, we're dissecting the legal and economic arguments around one of the most significant constitutional debates of our time.
Yeah, we're diving deep into the Affordable Care Act's individual mandate, and specifically that pivotal 2012 Supreme Court case, National Federation of Independent Businesses versus Sebelius. You'll hear the core legal interpretations from two, titans of the court, Justice Ruth Bader Ginsburg and Chief Justice John G. Roberts, Jr., and hopefully understand not just what they argued, but really why it mattered, and of course, the lasting implications.
Right. Our mission today is to get a handle on these different perspectives. Could the Constitution's Commerce Clause actually allow Congress to require uninsured folks to buy health insurance? And how did the Supreme Court end up navigating this really contentious issue?
It's a shortcut, hopefully, to being truly well-informed on a topic that, let's face it, touches pretty much everyone's lives.
Okay, let's unpack this then. The Patient Protection and Affordable Care Act, the ACA, or Obamacare as most people call it, the big goal was to provide a pathway for millions, something like 50 million uninsured Americans, to get health insurance.
Exactly. And a key piece, probably the most controversial piece, was this individual mandate.
So what did that actually require?
It essentially required most individuals to purchase health insurance or face a penalty. The underlying theory was pretty straightforward, actually. If you bring more people, especially younger, healthier people, into the insurance pool, it spreads the risk out, makes coverage more affordable for everyone.
Which helps pay for the sick people.
Exactly. And that was seen as crucial, particularly alongside other really popular parts of the law, like protecting people with pre-existing conditions. Wow. Insurers couldn't turn them away anymore.
Right. So proponents argued, look, this is the only way a market-based system can actually work to cover everybody. They said Congress had plenty of power, wide latitude under the Commerce Clause to do this.
But the opposition immediately cried foul.
Yeah. What was their main objection?
They claimed it was fundamentally unconstitutional, that the federal government just couldn't force people to buy a product or service they didn't want. They insisted the Commerce Clause only lets Congress regulate existing commerce, not, create it by forcing a purchase.
So a real clash of legal philosophies. Where did this ultimately lead?
Well, this intense debate, this fundamental disagreement over federal power, it culminated in that landmark 5-4 Supreme Court decision in 2012.
5-4. Always seems to be close on the big ones.
It often is.
Yeah.
And what's really fascinating here, and where our deep dive gets pretty interesting, is that even though the mandate was ultimately upheld, the 5 justices in the majority, they didn't all agree on why it was constitutional.
Okay. So the outcome was yes, but the reasoning was split.
Precisely. It was a deeply fractured decision, Ruth.
A fractured decision that, shaped an entire era of American healthcare. So let's dig into that yes argument first. The argument for the mandate under the Commerce Clause, specifically as Justice Ginsburg saw it,
Okay.
she was pretty firm that Congress had the authority here, right? And it started with just the sheer size of healthcare.
Absolutely. Justice Ginsburg saw healthcare provision not just as, a local issue, but a national concern of immense scale. She pointed out that back in 2009, Americans spent, get this, $2.5 trillion on healthcare.
Wow.
Yeah, that's about 17.6% of the entire national economy. But even more uniquely, she said, the market for medical care is one where all individuals inevitably participate. Sooner or later, pretty much everyone needs care.
And it's not just the size, it's that inevitability combined with the unpredictability and the sheer cost, right?
Exactly.
I mean, the average person might rack up over $7,000 in health expenses in a year. A single hospital stay could easily top $10,000.
These aren't trivial costs.
Not at all. People can't just shrug that off.
And this leads right to the crucial issue, the uninsured. You mentioned the 50 million or so back in 2009 who lacked insurance, but they still used healthcare. Over $100 billion worth of services annually.
So who pays for that?
Well, that's the problem. Because federal and state laws, plus, ethical obligations, often require hospitals to provide emergency care whether someone can pay or not. Providers end up with billions in uncompensated care. They're on $43 billion just in 2008.
Okay, so the hospitals eat that cost.
Not exactly. They don't just absorb it. They raise prices for everyone else. They pass that burden on to private insurance companies, government programs, which then leads to higher premiums for insured families. We're talking over $1,000 a year extra per family on average.
So that's the free rider problem Justice Ginsburg talked about. The insured are effectively subsidizing the care of the uninsured.
That's precisely her point. And it makes the decision not to buy insurance not just a personal choice, but an economic action with real, measurable costs imposed on others.
Which, in her view, makes it something Congress can regulate.
Yes. And she also argued that individual states couldn't really solve this alone.
Why not?
Well, imagine a state tries to set up universal health care. It might, as she put it, become bait to the needy, attracting sicker people, driving up costs, and maybe even pushing healthy residents and businesses out to states without those mandates.
Creates a race to the bottom almost.
It creates what she called a collective action impasse. States acting alone can undermine each other. It really points towards needing a national solution.
Okay, so Congress steps in. But instead of, say, a single-payer system, they chose the ACA, this hybrid approach, keeping private insurers in the game. But to make that work, especially with things people really liked, like guaranteed issue, no denial for pre-existing conditions and community rating, charging sick and healthy people similar rates.
The individual mandate became, well, essential.
Why was it so critical, though? Why couldn't you have one without the other?
Because without the mandate, you get this economic death spiral called adverse selection.
Adverse selection. Okay.
It means healthy people think, why pay premiums now? I'll wait till I'm sick. So they opt out. That leaves insurers mainly covering older, sicker, more expensive people.
So premiums have to go way up.
Way up. And eventually, insurers might just leave the market entirely because it's unsustainable. We actually saw this happen. 7 states tried guaranteed issue and community rating without a mandate back in the 90s. Their markets really struggled.
But Massachusetts,
However, did implement reforms with a mandate, and their market was much more stable.
Okay, so bringing it back to the Constitution, how did Justice Ginsburg connect all these economic realities, the cost shifting, the adverse selection, back to the Commerce Clause?
She argued the framers intended Congress to have broad authority over national problems where states were, in her words, separately incompetent. She pointed to Supreme Court precedent, focusing on 2 key principles. First, Congress can regulate activities that substantially affect interstate commerce. And second, courts should generally defer to Congress if it had a rational basis for acting and a reasonable connection between the law and its goal.
And the mandate met those tests.
In her view, easily. She argued it directly addressed the economic decision of foregoing insurance, an action or inaction that demonstrably affects the huge interstate healthcare market through that whole cost-shifting free rider problem.
Makes sense from that perspective. Now, let's pivot. Chief Justice John Roberts, he disagreed completely on the Commerce Clause point.
Fundamentally disagreed, yes.
He emphasized a very different concept. Enumerated powers. What's the core idea there?
For Roberts, the starting point is that the federal government isn't all-powerful. It only has the specific powers listed or enumerated in the Constitution. Everything else is reserved to the states or the people. He saw this principle of federalism as vital for protecting individual liberty by, keeping power diffused.
So, limited federal government, how did he apply that to the Commerce Clause?
He argued that the power to regulate commerce inherently assumes there's already commerce happening. There has to be some kind of existing commercial activity to regulate.
Okay.
In his view, the power to regulate doesn't include the power to create commerce by forcing someone into the market, like compelling them to buy insurance.
So he draws a sharp line, regulating what people are doing versus making them do something they weren't.
Exactly. He pointed to other clauses, like Congress having the power to coin money and regulate the value thereof, arguing that creation and regulation are distinct powers.
Was that distinction, activity versus inactivity, really clear in past cases?
Roberts insisted it was. He argued that even the most expansive Supreme Court interpretations of the Commerce Clause always involved regulating some form of activity. The individual mandate, he said, was different because it compelled individuals who were currently inactive in the health insurance market to become active. And he warned that allowing Congress to regulate inactivity would open up, quote, a new and potentially vast domain to congressional authority. That was his big fear, unlimited federal power.
That seems to be the core concern, which leads right into his famous or infamous broccoli horrible.
Ah, yes, the broccoli example. Remind us what that was about.
It was this vivid way of illustrating the slippery slope he saw. He asked, okay, if Congress can make you buy insurance today because not buying it eventually affects healthcare costs, Could Congress then make everyone buy vegetables tomorrow because unhealthy diets also drive up healthcare costs?
So where does it stop? Exactly. If inactivity leading to future costs is enough, what couldn't Congress regulate? He argued the line between activity and inactivity, doing something versus doing nothing, was a common-sense distinction the framers, as practical statesmen, would have understood.
But Justice Ginsburg had a counter to that, didn't she? About self-insurance and that Wickard v. Filburn case.
She did. She argued that choosing not to buy insurance wasn't really inactivity. It was actively choosing to self-insure, a different economic choice with market consequences.
And Wickard, what was that again?
Wickard v. Filburn is a classic Commerce Clause case from the 1940s. The court said Congress could regulate a farmer, Filburn, who grew wheat just for his own use on his farm.
Even though he wasn't selling it.
Right, because by growing his own, he wasn't buying wheat in the market. And if lots of farmers did that, it would affect the overall interstate market price and demand for wheat.
So Ginsburg used that to say, see, regulating someone for avoiding commerce is perfectly constitutional. Not buying insurance is like not buying wheat.
That was her argument. It showed that economic decisions not to participate in a market can still substantially affect that market and fall under congressional power.
Okay, so we have this fundamental clash. Ginsburg says Commerce Clause allows it. Roberts says absolutely not under the Commerce Clause. 5-4 decision. It really looked like the mandate was going down.
It certainly seemed that way based on the Commerce Clause arguments alone.
But then Chief Justice Roberts pulled off, well, a major surprise. How did the mandate actually survive?
Yeah, this is where it gets really interesting. Despite concluding the mandate was unconstitutional under the Commerce Clause, Roberts didn't struck down a law. Instead, he found a different path. He argued the mandate could be read not as a command to buy insurance, but as a tax on those who chose not to.
A tax, but the law called it a penalty, didn't it?
Repeatedly, yes. And that's why it was so surprising. Roberts focused on how the penalty actually worked. Non-compliance meant paying a relatively small fine to the IRS along with your taxes. Crucially, the law specifically barred certain enforcement tools, like criminal prosecution. It looked more like a tax consequence than a traditional penalty for disobeying a command.
So functionally, it acted like a tax, even if Congress didn't label it that way.
That was his reasoning. It was definitely controversial. Most lower courts had rejected it. Even the other 4 conservative justices on the court didn't buy it.
But the liberal justices.
The more liberal justices, who agreed with Ginsburg on the Commerce Clause anyway, decided to join Roberts holding the final outcome, even if they didn't agree with his taxing clause reasoning.
So they formed a majority to uphold the law, but for different reasons.
Exactly. It was a very unusual alignment. This maneuver allowed Roberts to achieve 2 things simultaneously. One, he delivered a narrow interpretation of the Commerce Clause, limiting federal regulatory power, which pleased many conservatives. But 2, he saved the ACA, President Obama's signature domestic policy achievement, from being struck down.
Interesting. So politically astute, perhaps?
Many commentators at the time certainly saw it that way. It allowed the court to appear somewhat impartial, navigating a hugely polarized political issue without completely siding with one political faction's view of the law's constitutionality.
This whole deep dive really shows just how complex constitutional law is and how directly it impacts the real world. And the ACA, of course, continued to evolve even after this court battle.
Absolutely. Legal decisions are often just one chapter in a long policy story. And it's worth remembering, too, that a lot of the ACA's architecture, including the mandate, was actually modeled on Massachusetts' 2006 health reform law, signed by then-Governor Mitt Romney, a Republican.
Right, the Massachusetts experiment. How did that work out in practice?
Well, in terms of coverage, it was largely seen as a success. By 2012, something like 98% of residents and nearly all kids were insured. Employer coverage went up, too.
But it wasn't all smooth sailing.
No, the cost issue remained a huge challenge. Even with the mandate and high coverage rates, per capita health spending in Massachusetts was still projected to nearly double by 2020.
So it highlights that these policy choices, even when they survive legal challenges, have complex, ongoing economic consequences. It's never just about the law.
Precisely. The legal debates happen, but the real-world impacts keep unfolding, raising new questions.
So we've walked through these really intricate legal arguments around the individual mandate. We've seen why 2 brilliant legal minds, Ginsburg and Roberts, reached such different conclusions on the Commerce Clause, and we understood that surprising twist, the taxing clause path, that allowed the law to remain intact.
Yeah, that core tension, between federal power, states' rights, and individual liberty It's just fundamental to American constitutional law. It hasn't gone away. This case really shows how sometimes, even when a law is upheld, the reasons why can differ profoundly, and those differences shape future debates about government's role in our lives.
So thinking about what this means for you, the listener, consider this for a moment. If my decision not to buy something, like insurance, inevitably shifts costs onto everyone else, at what point does my inactivity effectively become an activity with economic consequences that Congress can regulate, under its power, say, to promote the general welfare?
That's the multi-billion-dollar question, isn't it?
It really is, and it's a question that continues to resonate way beyond the Supreme Court room. It touches on how we define freedom and responsibility in a complex, interconnected society. Thank you for joining us on this deep dive. We really hope this gave you a clearer, maybe richer understanding of one of the most impactful legal decisions of our time.
Keep learning, keep questioning.
And we'll see you on the next deep dive.